Hello everyone, welcome back to Wills, Trusts and More. And of course we have Eileen, Kerlin, Walsh with us to help us separate all this legal documents and understand wills and trusts and other valuable documents that we should all have in place. But she's going to walk us through, and today we're going to be talking about trusts. And yes. I want to start out by saying I did get a phone call from our last show, and it was a husband and wife, and they were just totally overwhelmed with all the stuff that we've been talking about, and very much encouraging us to continue with the show. So they thought it was great. They have their documents in order, but they're always interested in making sure that they're doing the right thing even when they get older. So we have a good thing going.
Wonderful. That's validating.
You have a good thing going.
Yes, indeed. And we have had phone calls too. We've had inquiries. We've had requests for consultations. So I feel that we're getting the information that our audience is interested in and wants. So that feels terrific.
Good. Well, we'll thank the viewers for interacting with you.
Yes.
And with Channel 4. And hopefully we could share more information, and we're going to get into trust. And I'm going to ask you, what is a trust, and what does holding title in trust really mean?
Trust can be most simply understood as a form of holding title. The term trust can be confusing, it can be intimidating, but if we just think of it as another way to hold title, most of us have bank accounts, most of us own homes. We know that we can hold a bank account in our own name, we can hold it in joint tenancy, we can hold a property that way. Trust is just another option for holding title that comes with a whole lot of benefits. And those types of benefits and types of trusts are what we're going to talk about today. But the understanding is best done with this notion that trust is just another way of holding title.
Okay. And are trusts for the rich people only?
Very common misconception. There was this idea that trusts are simply for the billionaires, the Rockefellers, and that's just simply not the case. Trusts are for everyone. The benefits are for everyone, and we're lucky here in Illinois that we have a very trust-friendly state. They're less expensive than in some of the other states where they're used a lot, such as Florida or New York. They're very, very well understood. They're well used, and we have good trust-friendly law. So it's a terrific state. We use trusts a lot. Great benefits, and they're available for just about anyone in their estate planning needs.
Now, what is the most commonly used type of trust?
Great question. There are many types of trust out there. We do lots of different specialized trusts, but I think we could comfortably say that about 90% of our audience in our community that we serve would need just either one of two types, and that's a simple land trust or a living trust. Now, a simple land trust, again, very widely used. A lot of people would have their property in trust at the bank. That's one type of a land trust. You don't need to use a bank as a trustee. You can have a standalone trust. But a land trust would be for someone for maybe their principal asset is their paid off home. That everybody wants to avoid probate. But if the only asset we have that's likely to push our estate into probate after our death is our home, we can use a simple land trust, get the home in there. If you're going to use a bank or a trust company, they are the trustees. If you do it standalone where you can cut out those fees, then you are the trustee for your lifetime. It's a husband, wife, then mom and dad are the trustees. If they have children whom they would want to take after they pass away or just take over when they no longer want to take care of the property or the administration, they could name the children as trustees. And that's just one scenario. Of course, everybody doesn't have that nuclear family scenario. But the land trust is the most simplest form of trust and widely used.
I have a question. If let's say a home is put into trust, can it be in trust under the bank's name rather than your own personal name?
Yes, and that's one of the benefits of trusts, and certainly with the bank. There's privacy of ownership, and if you get your property into a trust at the bank, the trust number and the name of the trust holder, typically the bank, will be what will show up in records. So it is a good way to hold property privately and keep it out of the county records. I think everyone has had that letter saying, it's a scam letter. We were just talking about scams a little bit earlier, where we can get you a copy of your deed and it looks like it comes from the recorder's office. Because land ownership is a public record, it does leave you vulnerable in some ways, one, to scams. And if someone is doing a search of you or looking to see, do you have any property for whatever reason, maybe someone wants to file suit or a claim, the privacy of ownership offered by a trust at the bank or the trust company is one of the huge benefits. That is not a benefit offered by a typical standalone trust. And if we're going to look at land trusts and kind of balance between, do we want a trust at the bank or do we want our own land trust, it might be privacy of ownership plus a yearly fee, plus small fees if you need to take the property out or you want to change the beneficiary. In a standalone trust, you don't have those fees. There are some ways you can have privacy of ownership, but it's not as effective as the just a simple trust number with the bank trust. So that's a great point, and one of the reasons that trusts at the bank are used is that privacy.
Okay, and then that would lead to, will a trust protect you from creditors?
Great question.
Because you touched on that a little.
Yes, yes. And there's the privacy is a little bit of a protection in itself. But while there are some misconceptions like trust being for the rich, sometimes there's a perception too that trusts are Fort Knox. You get your property in the trust, that you lock the door, throw the key, no one can access it. That is simply not the case. A land trust does have some protection. The one that we just discussed, as well as the fact there's this little artificial almost, but there's a subtle shift in the type of property when you put it in a trust, because you're now the beneficiary of a trust. It's considered personal property rather than real property. There are some benefits for creditors with just any kind of a trust, but it's not automatically asset protected. Another very common type of trust that our clients use and that our community typically is interested in is a living trust. Beautiful. That goes beyond just property. We can retitle our accounts, our money market account. We can name the trust as beneficiary on our insurance policies, on many, many different kinds of accounts. A living trust is a bigger trust than a land trust. We can put in not just Illinois property, but if you have a Michigan property or a Florida property, many, many benefits to it. Avoid probate. All of these trusts will avoid probate. Still not asset protection. Asset protection is a very specialized area of law. It's a very expensive field to be in. There are certainly ways that we can protect assets, absolutely. But the key to asset protection is giving up access. Most of our mothers would have told us when we were little, we can't have our cake and eat it too, and that always comes to mind when we're discussing asset protection. Certainly we can set aside assets if we're prepared to give up the use of that asset. And if we get our assets set aside before there's any lawsuits, before there's any judgments, before we need government help, before we need Medicaid, if we have enough time, then we are able to protect that asset. But we need time. We need to make sure that there's nothing that would suggest that this is a fraudulent transfer. And of course the disadvantage is giving up the use of that asset. If we're to maintain the idea it's not our asset, therefore creditors can't have it, we also have to take away our access to it. We can't play the game both ways. Now, we can keep that asset in an income trust, we can have income from it, we can make sure that asset goes to our children rather than a nursing home. Lots of things we can do, but we've got to make sure that we can give up the asset, that we can put it in something irrevocable. And for many of our clients, that's the difficult choice, because ultimately we want you to have the use of your assets for all of your life. Because if estate planning largely is concerned with passing the assets on to the next generation, that is only after you use them. But that does certainly, when we have extensive assets and we have maybe a high-risk profession like physicians, our typical clients where we do use income trusts, the facility is there, but it comes with that difficult choice, giving up access to the asset.
Okay, and I have a question here, and I want to read it to make sure I get it right. Is there any trust that can save my assets from being exhausted due to a nursing home cost?
Nursing homes. This is a huge question, and when you're in the area of estate planning, we probably get this question at least once a week. Our options are somewhat limited. The states are under pressure. The state of Illinois, even just last summer, took away some of our options in this field. Yes, there are options. They are limited. The key is time. Just as we said with asset protection, the key is time. If we do have an asset that we're able to set aside, we know we're not going to use it in our lifetime, we know we want it to go to the children rather than the children of a nursing home's owner, then we can get that set aside. Illinois is now fully on board with the 5-year look back. So we've got to have lots of time, and we've got to not need that asset for ourselves, and those are, those are not something that everyone always has, but we can certainly get the asset protected from loss to nursing home. If we don't have that time and we're at the nursing home door, there is still something we can do. I always say there is a trust solution to every problem, but now of course we're much more limited and we don't have that 5-year to completely protect the asset. So there are pool trusts. They're called the payback trusts, whereby say mom and dad, or say mom's gone and dad only has $100,000 left, and we know with nursing home costs that's going to be expended in a very short amount of time. We can put that into an approved payback trust, whereby we don't have to make dad penniless, because to qualify for Medicaid you have to have less than $2,000. So it's sad that we have to make someone who worked their whole life penniless before they can get the kind of aid that they need. So we can take that money, put it in a pool trust. They're called Disability Pool Payback Trust. It's still there for dad for as long as he needs his extra needs or anything, so that he can qualify right away, and then the payback comes after he passes away. Probably what's left in that trust will go to the nursing home or will go to the state. But at least we have some options. So there's always some option, no matter how late in the process you start to think about it, but our options are certainly limited because the states are squeezed for funds, and they're really trying to make sure we do spend all our money before they're prepared to chip in.
Wow, well, that's a lot of information, and I'm sure there are some viewers that do want to talk to you, and we're going to give you Eileen's phone number and address so that you can make your phone call to her and ask her questions and go from there. I have another question here. What about special needs trusts? How can a special needs trust shelter assets for my mentally or physically disabled loved one?
Wonderful. We do get this question a lot also. Again, this sort of follows from what we talked about before when you need government help with nursing home and Medicaid. If you do have a loved one who has special needs, who has a severe mental or physical disability, often their medical care is very expensive, and often there is help from either county or state or federal means. Now, in order to qualify for that kind of help, of course, again, that person, the special needs person, can't have any money, again, less than $2,000. Okay. So what parents often had to do when they had a special needs child was disinherit them in their estate planning, which was really painful, because even if they had a modest estate, if that child took anything over $2,000, then they would lose their benefits. Now we don't have to do that anymore, because we do have these wonderful special needs trusts. And mom and dad can set it up in their estate plan. They can be set up standalone right now. If maybe grandma wants to give some money to perhaps a Down syndrome child, that money can go into a fund for that child, and it's not going to, even if there's very, very large amounts of money, we don't have caps on what can go into the special needs trust, and that money is there for vacations, for maybe a specially adapted vehicle, a specially adapted home, anything that would provide that special needs person with extra comfort and care beyond what they're already being provided by any government agency. terrific tool, and it's so encouraging to be able to help people with a trust like that for the special needs person, because parents of a special needs child, maybe now a special needs adult, that's one of their greatest concerns is how are we going to have them taken care of if we're no longer able to do it. And this is a field where we can really help. Special needs trusts are wonderful.
Are there any other types of trusts? I'd be willing to bet, because you touched on that, there's a trust for almost anything and everything.
Yes. Children's trusts, another very typical type of trust. And I think if I talk about the trusts that we set up very typically and regularly, then that's probably what most of our audience is going to be most interested in. Children's trusts we set up all the time too, very typical. This might be where a younger family now have small children and have looked at each other and thought, well, what if something happens to us? What's going to happen to our children? So they might want to start thinking about guardianship for the children. They might want to think about trusts. And if it is a young family making provision for that remote possibility that something should happen, both of them while the children are little, then they're usually done within wills. These can be testamentary trusts. They don't have to be standalone, just in the parents' wills. How children's trusts typically work is that if we have 3 or 4 children of varying ages, it's a single trust fund until all the children get to a particular age, maybe 24, when they'd have an education or maybe even an advanced degree. At that point, meaning that some of the children, the younger one is probably going to get more of the single fund than the older ones. But that's fair, because the older ones had more of their parents while they were still here.
Right.
After the age of 24, maybe a very typical separation of what's left then would be each child gets 1/3 at 24, 1/3 at 27, and 1/3 at 30. And even a lot of young parents who are just starting to accumulate their assets, they have young children, we all know how expensive they are. I have 4 of mine. Every day I'm reminded of that. But if young parents do pass away, there usually are sums of money. There are often insurance policies, even wrongful death lawsuits. There are often benefits. People are quick to step in when young children are in need. So if you are in a position where you'd like to do something for this for your children, but are thinking, we really don't have anything yet, it's always a good idea to get something in place should the worst happen. If the children grow up and the parents stay healthy, as we hope they do, then they just grow out of the trusts, and there will be provision in the will for how assets will be distributed when the children are adults. One of the things we try to do with estate planning is take into account at any stage the succession of events, so that if children do grow up, or your chosen executor moves away, or somebody passes away, we have succession, we have alternate language, so that you don't always need to go running to get your estate plan changed if a life circumstance changes. Now, sometimes something will change dramatically, or you'll change your mind about your agent, and there will be opportunities for amendments, for codicils. But largely, we try to leave no stone unturned, to try to think of anything that might happen, so that you may very well not ever need to dramatically change your estate plan again. We always review them. We always say every 2-3 years, sometimes with a more complex estate plan, or if you're in advanced years, we might look at it more often. Some estate plans need a review every year, but typically 2 to 5 years is all you really need to think about when you have all this great stuff done.
And then the closing question always is, when should you start a trust?
When?
And that is
and you know my answer.
NOW, now.
Always now, always now. And if you think of many of the things we talked about, that when you're youngest, when you're healthiest, when you're most competent, when you're able to think about this, when you have time to make decisions, before there are any accidents or lawsuits or anything that might affect your assets, you want to be thinking about getting all of this in place now. So it's always a good idea. One little word of caution. I told one of my clients that we were going to be talking about trust today, and she'd had a bad experience with a trustee, and she said, please remember to tell people to think very carefully about whom you name as trustee. So I would like to address that. You want to think, When you're doing trusts, just remember now, the whole point of trust is that we're avoiding probate, we're avoiding courts, we're keeping your estate plan private, we're keeping it within the family, we're having everything moved privately. That means we need to trust those people because there are no courts breathing down their necks. There really may not even be lawyers involved. So choose your trustee wisely. Choose someone that you believe, one that you trust, that's going to act in your best interest and then everyone else's. Someone who's a good financial head if it's a financial trustee. Disability trustee, someone who's good with healthcare or difficult emotional or medical decisions. So do give a great deal of thought. When clients come to me, I'd say to them that maybe one of the hardest questions I'm going to ask you today is, who are we going to put in these positions? Powers of attorney, as we've talked about before, executors of wills, trustees of trusts. Give as much thought to your trustees as you do to the beneficiaries. It's much more important that we name, say for example, the children that have the best head for this, or not necessarily the person who's local. Let's not be too concerned with hurting someone's feelings. It's much better to name a trustee that you know is going to get the job done timely and be fair to everyone and keep the best interests of the trust and the distribution in mind, and then you've really succeeded.
Is it important that you have a contingent trustee?
Absolutely, absolutely, and that's a terrific question. Again, going back to leaving no stone unturned, we named, typically our clients, the estate planning clients, are going to be their own trustees, whether it's a living trust or if it's a standalone land trust. So after you want to think about maybe next generation. We want to make sure, if we're estate planning now in maybe our 50s or 60s, we're thinking, well, maybe by the time I need this help during my lifetime in my 70s or 80s, maybe my sisters or my brothers or the people that I trust now might also be starting to need a little help too. So it's wonderful if you can name the next generation, and then we want to be able to name succession, and then we always have the safety net. Estate planning is chock full of safety nets, so we will always use language in there to say that if there is no trustee willing or able to act, then we can name a professional trustee. Professional trustees are wonderful, so if anyone is thinking, I don't really have a family member, who's going to be my trustee? We do have professional corporations that this is exactly what they do. They're a beautiful option. The only downside to a professional trustee is the expense. They're typically much more expensive than a family member. A family member is going to be compensated for acting as trustee either during your lifetime or afterwards, and we make provision for that. Professional trustees tend to sometimes charge a percentage of the estate as well as maybe a monthly or a yearly fee, depending on how much work you need them to do. If you just have an outright distribution to everyone, that's going to be done within 6 months probably of your death. If perhaps you either have enough wealth or maybe difficult situations in your family whereby someone's going to be getting a payment every year, maybe every 6 months, every 5 years, that's going to call for the trustee to stay involved. And that's where the professional trustee can be expensive. A wonderful option if either the difficulty of the estate plan or the size of the assets warrant it. So if in doubt and we can't afford a professional trustee, wonderful. Otherwise, choose wisely and carefully amongst your family members so that we know the trustees are going to do all these wonderful things that we put the trust in place for in the first place.
Very good.
Thank you.
Eileen, is there anything else in conclusion? Did we cover all of the topic of trust today?
I think we did. I think we did. Living trusts, I think of everything we talked about, of all the trusts that we do would be by far be the most typical, and that is what our clients have the most questions about. There's another type of trust that sometimes maybe I could mention briefly, a charitable remainder trust. Sometimes clients will have bought a property maybe in the 50s, maybe it's an apartment building in the city, they bought it for $50,000 and now it's worth several $100,000 and there's a huge capital gains tax. We have wonderful trusts where we can take that asset, cut out paying all the tax on it, get it into a certain type of trust, make sure the full money We do use a charity, but we can also attach, and I don't want to get too complicated here, but we can attach certain types of annuities to it, whereby we can take the full value of that very highly appreciated, expensive property, get it to the family, get some to the charitable institution that of your choosing, and still make sure you have all the income you need for your life. Trusts are wonderful. They're magical. Many solutions. We even have pet trusts. If your pet is the object of your bounty and you want to make sure that it's well taken care of and the money goes that way. So I think that really helps illustrate we do have a trust answer for every problem. Thank you.
Okay, well, for the viewers that want to talk to the law offices of Eileen, Kerlin, Walsh, we're going to give you the number. It should be at the bottom of the screen, 708-448-5169. And for the local people that would like to visit her, you can go to 11301 South Harlem Avenue. That's 11301 South Harlem in Worth. And she'd be happy to address and make an appointment with you and maybe actually help you. You might become a client.
Yes, indeed. I'd love to hear from you. Thank you. Any question, anytime. Thank you, Ron.
Very good. Thank you for coming with us on the show. And we'll see the viewers in about a month on another interesting topic.
Lovely.
Okay.
Thank
you have a good day. Bye-bye.